Yes, Mr. Parkinson.
Thank you, my lord. Just a couple of points before I start. I spoke to Mr. Leader over the lunch break about timings going forward.
Oh yes.
I'd share those before. So I'm proposing to be up to 3 o'clock, hopefully not before.
Yeah.
Up to. Then Mr. Leader anticipates to be up to 30 minutes. So
Okay.
that should allow us to finish. And we give Mr. Fraser quite sufficient time to do a reply.
Thank you for that.
And then in terms of the citations,
Yeah.
I don't know what's easier, whether to give them to you now or as I go to each authority to give them to you.
I think as we go is probably best, yes.
Okay, I'll do that.
Thank you.
So just
And I see Mr. Fraser has kindly been, or somebody has been kindly copying.
Yes, I've had partial success, my lords. I've got the Lambeth authority from the law reports. And I've got I'm your man from the law reports. The others not yet, I'm afraid.
All right. Well, that's very helpful. Thank you. Do you want to hand those up now, or are you expecting deliveries in the course of the?
I'm not expecting any deliveries. No.
Okay. Well, why don't we just take those now while we're pausing? Yes.
What might be useful after we've concluded is if somebody takes the index to the authorities bundle and simply produces one which has, in addition, the references to law reports where there are law reports.
Yeah.
Yes.
That would be really helpful. Thank you.
Thanks very much. And just by way of timing, I'm not usually a long replier, so
No.
we'll
Thank you for that. Anyway, we're not under huge pressure, it seems. Thank you. Hmm? Thank you very much. Right, we've got Lambeth and we've got I'm your man in the law, both in the law reports.
Thank you. Oh, thank you.
Thank you. Yes.
Thank you, my lord. So just before lunch, I was dealing with the correct interpretation of the 1987 Commission and how the description has to be read together with conditions E and F, and doing so particularly by reference to the touring unit results in a situation where 30 of the 57 caravans permitted could not be occupied by someone's permanent residence. I thought it might just be helpful just to very quickly run through how we say that then plays out in terms of the numbers and what each type could be used for. So the permission, if one excludes the chalets, which of course aren't caravans, permitted the stationing of 57 caravans, and that's adding up the residential vans, the 9 residential vans, the 18 static vans, and the 30 touring units. So 9 were permitted to be residential vans, and that would embrace both permanent residential occupation and holiday use, because holiday use is a residential use, with no restriction on when those units could be occupied, because condition E doesn't bite on residential vans. Then there's 18 static vans, which, for the reasons I went into before lunch, the inspector found could be used or occupied for both permanent residential occupation and holiday use. But those caravans couldn't be occupied for holiday purposes for 4 months of the year. That's the effect of condition E. And then the 30 touring units, so that's over half, total of 57. Those were permitted for holiday use only, because the effect of conditions E and F is that they couldn't be occupied as someone's permanent residence. So that's how we say, if you read the conditions and description of development together, the permission breaks down. And that's then reflected in the inspector's overall summary of the permission, which is worth going back to. It's page 226 of the bundle. Paragraph 47. she says, in my judgment, the words in the 1987 permission permit a caravan site at which caravans provide both permanent residential accommodation and holiday accommodation, the year-round use of the latter being prevented by condition. And that is we say, an apt summary of that breakdown that I've just provided. That finding was then endorsed by the judge. So tab 10, paragraphs 37 to 39. My lords have already been taken to. I'll probably just go straight to paragraph 39, where that finding at paragraph 47 is specifically endorsed. And we say that that is correct, the correct interpretation in law of the 87 Planning Commission. Before moving on to I Am Your Man and the case law and what flows from that, I'll just quickly deal with the statutory definition of caravan site and how that feeds into this. Now, we would accept as a general proposition, and there's case law in the caravan context that supports it, that where statutory words are used in a planning permission, the presumption is they bear their statutory meaning unless there's contrary indications. But of course, the wording caravan site is not used in the description of grant here. So the principle doesn't come into play. And that differs from the Breckland case that you were taking to. My Lord Lewis, I think, asked a question in relation to this. In the Breckland case, the word caravan site was used in the certificate, and I'll just, for your note, give you the reference. It's paragraph 6 on page 145.
Do you want us to look at that or not?
No, it's just the certificate says. And ultimately, as Trump makes very clear, and all the associated case law, we're asking ourselves what a reasonable reader would consider this permission meant. And I would submit that a reasonable reader would consider that this granted permission for caravan site, yes, but one in which specific numbers and types of caravans permitted were expressed. And overall, because 30 of the 57 could not be used permanent residential, and 27 could be used for that use, they would take the view, well, this is a caravan site where the caravans provide both permanent residential accommodation and provide for a holiday use, which is, perhaps not as eloquently expressed as the inspector, pretty much what she said at paragraph 47. She said, in my judgment, the words of the 87 permission permit a caravan site in which caravans provide both permanent residential accommodation and holiday accommodation. So yes, it's a caravan site, but it's a caravan site that is in a mixed tenure use, if I can put it like that, as a result of the effect of conditions E and F. So then I was proposing to deal with I'm Your Man and how that feeds into how the inspector should approach the certificate appeal. And I'm going to start off by dealing with the statute, because ultimately planning is a creature of statute, and where you have judicial concepts like the I'm Your Man principle, and actually what it boils down to is the judicial application of the statute to the facts of a particular case. And looking at this through the statutory provisions, it's quite clear, I would submit, the approach that should be taken, and it's the approach that was taken by both the inspector and the judge here. So the starting point is section 192, which is at page 25 of the authorities bundle. In section 192.2 says, if on an application under this section, the local planning authority and provided with information satisfying that the use or operations described in the application would be lawful if introduced or begun at the time of the application, they shall issue a certificate to that effect. And in any other case, they should refuse the application. And on appeal, an inspector is asking whether the decision made under that section is well founded or not. The definition of lawful is then given section 191(2). Which is on page 21. For the purposes of this Act, use and operations are lawful at any time if A, no enforcement action may then be taken in respect to them, whether because they did not involve development or require planning permission because the time for enforcement action has expired or any other reason, and B, they did not constitute a contravention of any of the requirements of any enforcement notice then enforced. Now, obviously there's no enforcement notice here, so it was necessary to consider 2A, whether the use sought by the certificate was something that enforcement action could be taken against. And subject to the time limits for enforcement action could be taken where there's a breach of planning control. And the definition of breach of planning control is at section 171A1, which is page 13 of the bundle. And I would submit that this is a key provision because the distinction between A and B helps provide a way through Winchester, Isle Man, Cotswold, etc. So for the purposes of this Act, carrying out development...
Which says I can't find one... Did you say 181?
Oh, sorry, my lord, it's 171.
171, I thought it was...
171, capital A.
Yeah.
1.
A1, page 13. So there's two limbs. For the purposes of this Act, carrying out development without the required planning permission, or B, failing to comply with any condition or limitation subject to which planning permission has been granted, constitutes a breach of planning control. And that word limitation one then sees in the Isle Man case law. So there's two limbs, carrying out development without planning permission, or failing to comply with condition or limitation. Either of those is a breach of planning control, and development amounts to breach of planning control by virtue of the other provisions I've gone to. It's not lawful. Now, here, the inspector was very alive to the fact that 80 caravans, all in permanent residential occupation, was not a breach of planning control under section 171A1B, i.e. it didn't amount to a breach of condition. And we can see that from the decision letter. Take my lords to a couple of references. The first is paragraph 34, which is on page 224, full bundle. And she says, paragraph 34, in this current appeal, it's common ground that whilst the description of development permitted by the 87 Commission includes reference to specific numbers of caravans, this does not limit the use of the land to the numbers specified. It would be open to the DMPA to impose such a condition on the 87 Commission, but it did not do so. The DMPA accepts that an increase in the number of caravans would not be a breach of condition because there's no condition limiting numbers. Then there's also paragraph 30 on the preceding page, page 223. Again, it's recorded, there are no conditions which restrict the number or type of occupation of the caravans permitted on the land. Now, the I'm your man principle is that one cannot read the description of development as imposing a condition or a limitation in very, very simple summary. The inspector was well aware of that. We can see that from paragraph 46 on page 226.
Sorry, paragraph
Sorry, my lord, it's page 226, paragraph 46.
46.
Where she sets out the description of development, which we're all familiar with, and the breakdown. But then the last 4 lines says, that's the existing lawful use of the appeal site. This description does not, for the reasons discussed above, serve to limit the number or type of caravans that may be stationed on the site. But that does not mean it can simply be disregarded. I'll come back to why it can't be disregarded. But the reasons discussed above include paragraph 31 onwards, which starts on page 223. And my lord, I'm not going to take your lordships through that, but I would submit a very precise and correct summary of the I'm Your Man case law. It hasn't been the subject of criticism, but it's summarised particularly at the bottom, paragraph 32, page 223. We're 2 lines up from the bottom of the page, the inspector says, there's a difference between a limitation of numbers of caravans in description in the grant of permission and a limitation of such numbers in the form of condition. Only the latter was capable of imposing a limitation in law. So the inspector is well aware that having, for example, 20 static caravans on the site doesn't amount to a breach of condition. Ditto having 35 touring caravans.
Is the word limitation defined in the statute anywhere, or do we just read it as an ordinary English word?
It is. Is that section 72? Or maybe. No. It's in the development order, Mr. Leaders. Help me out with. So it's not in the statute. It will be set out in the I'm Your Man case.
Should we just find that?
Well, I suppose we'll get to it if you're taking us to that case.
Yeah, perhaps I could come back to the.
Yeah, I don't take up time on what might be a red herring.
No, it is important. Unfortunately, I haven't got the.
Well, it's section 60. It's the 4th page, it looks like.
Is it 4th page?
First full paragraph by section 60, planning permission granted by development order. Is that it?
That's it. Yeah. Yeah.
So a limitation is a limitation in the order.
Yeah. Such limitations as may be specified in the order.
Yes, I wonder whether we could find, is there a statutory definition of limitation as such?
In the 1990 Act? I don't think so, but I couldn't say that with.
No, I simply cannot remember.
Can I check that? I don't think so, but I would need to double check.
Yeah, no, but perhaps come back to that.
Yeah. Thank you. But in the context of this case, what we're dealing with is conditions on a planning permission. And going back to
the reason I asked the question is I was just wondering why, although 9 residential vans is not a condition, why isn't it a limitation?
Yeah. Yeah, no, I can see the basis of the question. I mean, the way the inspector has approach this algorithm is the right approach, which is nothing in the description is either a limitation or a condition. Sorry, description of development here and the numbers and the types expressed of different caravans don't amount to conditions or limitations for the purposes of section 171A, going back to page 13 of the bundle. So failure to departing from those numbers doesn't amount to a breach of planning control under that subsection. But it's still necessary to consider section 171A1A, i.e. would stationing 80 caravans on the site for the purposes of permanent residential occupation amount to the carrying out of development without the required planning permission? And that requires consideration of what does the 1987 planning permission grant planning permission for? What are the words of the grant? Does what's proposed fall within that? And if it doesn't, does it amount to a material change of use? And one can see that from the Winchester case. Which we have starting at page 198 of the bundle. My lord, so don't propose, because we looked at it already this morning, and it's also summarised in the judgment, to go through this in a huge amount of detail, because for my purposes, I can just go to the last paragraph, which sets out the approach, because I don't understand actually it's being disputed. It's paragraph 26 on page 207. And Lord Justice Sullivan says, it's possible that the use of the word limitation in the judgments contributed to the misunderstanding of the effects of the I Mill-Man line of authorities. The simple proposition that should not be lost sight of is that the use for which a planning permission is granted must be ascertained by interpreting the words in the planning permission itself, which is what I've been doing so far. Whether other uses would or would not be materially different from the permitted use is irrelevant for the purposes of ascertaining what use is permitted by the planning permission. And then this is the key bit. If the permitted use has been implemented and a change, and I think that should say from, a change from the permitted use takes place, it would then be a question of fact and degree whether that change is a material change of use. And that reflects section 171A1. You can have a breach of planning control through a material change of use without planning permission, even if you do not breach any condition or limitation subject to which that planning permission has been granted. And that is what the inspector's doing here. Looking at what's been permitted, looking at what's proposed, asking, does what's proposed fall within the scope of the permission? And then if it doesn't, is it a material change of use? And we can see that from paragraph 5 of the decision letter on page 219. Which sets out the logical step approach to take. We'll approach this task by looking firstly at the status of the various planning permissions which have been granted for land. This will establish the existing lawful use of the appeal site and enable an assessment of whether or not the proposed stationing of up to 80 caravans for human habitation would fall within that existing lawful use. So of course, if it fell within existing lawful use, it has planning permission, so it doesn't amount to breach of planning control. If it does not, it would then be necessary to determine whether the proposed use would constitute a material change from the existing lawful use. That's because a non-material change could be made lawfully. That's because it's development, doesn't require planning permission. But a material change of use would amount to development, for which a new grant of planning permission would be required. She then does that by first of all going through the status of the existing permissions, then reaching her judgment that I've gone to at paragraph 47 on page 226, which is that this is a permission for a caravan site that provides both permanent residential accommodation and holiday accommodation. Then the second half of that same paragraph says that the stationing of 80 caravans, all of which could be used for permanent residential occupation, doesn't fall within the scope of that. And then paragraphs 49 onwards asks yourself the question, well, is that change material? Because of course you can have a situation where a proposed use doesn't fall within the scope of the permission, but isn't a material change. So for example, if you had a planning permission for the stationing of 100 caravans, certificate application for 101, well, 101 caravans falls outside the scope of the permission, but it may well not be a material change, and therefore not development requiring planning permission, and therefore lawful under section 171A1A. And then her overall conclusion, paragraph 66 on page 230, for the reasons given above, find that the proposed stationery of up to 80 caravans is not provided for by the 1987 permission. Rather, it amount to material change of the use of the land for which planning permission would be required. On that basis, the requested certificate that such a use would be lawful cannot be granted. And that is an accurate summary of the statutory regime and the distinction in section 171A1 between the two different types of breaches of planning control. Development requiring planning permission on the one hand, breach of condition on the other. Not a breach of condition, but it is development requiring planning permission. It falls outside the scope of the permission and is a material change. And that's how she's approached this. That was upheld by the judge. And really, if you're with me on the correct interpretation of the 1987 permission, the findings she makes are, we would say, obvious, because no one would look at the permission for 57 caravans, 27 of which can be used for permanent residential occupation, 30 of which can't, and say to themselves, well, I've got a permission here for 80 caravans, all of which can be used as someone's permanent residence. That's not what the permission is for. Now, of course, you have to go to the next stage and ask yourself, well, is it a material change? Is it development requiring planning permission? And that's my Lord Lindblom's second main issue. In terms of the first issue, that's the right approach to take. And then if I could just sort of sweep up some of the other points that fall under the first main issue. But the first is that it's suggested, I think, that at paragraph 47, page 226, the inspector has found that to fall within the scope of the 1987 permission, there must be at least one caravan in use to provide holiday accommodation. There's 2 points to make there. First, the inspector was well aware that even if the certificate was granted, there would still be structures on the site that would be occupied for holiday purposes. And we can see that in paragraph 60 on page 229. the last sentence. The proposal for the stationing of up to 80 caravans on the planning unit could only be in addition to the existing chalets and the protected trees not in place of them. So it was recognised chalets would remain and there would be still holiday use taking place on the site. But to quite a large extent, this was to do with numbers. Going from 27 caravans, which could be used for permanent residential occupation, to 80. And 47, paragraph 47 has to be read in light of what the inspector said in the preceding paragraphs. And I'll just give a couple of references. So paragraph 36 on page 224. Records the appellant's submission. Last line, that the 87 permission expressly provides for an unrestricted number of residential caravans for year-round occupation. And paragraph 43 on page 226. The inspectors looked at various authorities and appeal decisions, and it says, I do not consider they support the appellant's argument that because there are no conditions limiting the number of occupation of non-holiday caravans on this appeal site, it must follow that its use for any number of caravans for residential purposes would be lawful. And then a similar statement at paragraph 46. So what the inspector is saying at paragraph 47 is that if I granted the certificate, or if I granted a certificate, the effect would be that any and all caravans on the site could provide permanent residential occupation, i.e. you could have 80 caravans providing permanent residential occupation. That doesn't fall within the scope of the permission that only provides for 27.
She says 27, does she?
She doesn't give the number 27, no. It's paragraph 35, where she... paragraph 35 explains her interpretation of condition in there. So the effects of paragraph 35 is, as she says, conditions E and F would frustrate any attempt to occupy touring caravans for permanent residential rather than holiday use. But that the 18 static caravans could be used for both holiday or permanent residential. So that's the static caravans and the touring caravans. And then the residential vans, I don't think there was ever any dispute that the residential vans...
Did you say paragraph 35?
Yeah.
Sorry, I'm trying to find the numbers.
So the numbers aren't given in that paragraph.
Oh. Right, well, if we go back to the planning permission, perhaps we can do the arithmetic for ourselves.
Yeah.
9 residential vans, and it's the 9 plus the 18, is it?
The 9 plus the 18. Because, as the inspector says at paragraph 35, the 18 can be occupied as someone's permanent residence.
Sorry, say it again.
The 18 static caravans can be occupied as someone's permanent residence.
Does she say that?
Yes, I think that's what she's saying at 35. And then it's made clear at paragraph 52, on page 227, where she says there's no condition which would prevent the permanent residential occupation of the static van.
Yes, you can. What you can do, you're saying, is infer from her reasoning that these conclusions relate to 27 in total caravans, namely the 9 residential vans referred to in the description and the 18 static vans referred to in the description, added together.
And then the balance of the is the 30 touring units, which she says in clear terms of paragraph 35.
I don't know if you're going to come back to that, but when you're on to the distinction between the 18 that can be used for residential and the 30 that are touring and clearly must be holiday, part of Mr. Fraser Urquhart's case is that a caravan is a caravan, and it is not legitimately part of the description of the land use characteristics, that is holiday rather than residential. I think you said you're going to take us to a case called Moore to show that's wrong. Are you coming to that, or?
I can do that now. I mean, Moore is a case to do with dwelling houses and holiday houses. It's not a caravan case.
No, but it must. If you could have a distinction between a dwelling house and holiday accommodation, and a dwelling caravan and holiday caravans, isn't it the same principle? Or
yes, I would say so.
Oh.
Yeah, because for the reasons I've said, the statutory definition you have of a caravan site isn't of much application here when you've got a specific permission. Would it help? I'll go to more now.
Oh, but yes, whenever's convenient. But you did say that you were taking this to a case that would, you said would answer a caravan by any other name as a rose.
Yeah.
Rather than caravan.
I'll do that now. So more is the authorities bundle of that.
This isn't reported either, is it?
So this is reported. It's 2013 APL 192.
Sorry, give it the page number again.
It's page 286. So, if I just take you through this. So we start off with paragraph 3, see what the case is about. So the local planning authority has issued an enforcement notice alleging a change of use from a C3 dwelling to use as commercial leisure accommodation, which doesn't fall within class C3 and therefore constitutes a sui generis use. And the notice required that use to cease. Paragraph 5, there's an appeal against the notice and the inspector dismissed the appeal on all grounds. We then jump ahead to paragraph 25. On page 293. That decision was challenged on 2 grounds. And it was submitted that where there's permitted use as a dwelling or dwelling house, that use lawfully includes not only occupation by an individual family as a permanent home, but also the use of the dwelling for holiday or temporary occupation. And so that was the ratio of the court's decision in Moore, which is another Moore case. That's the context of what's been argued. And Lord Justice Sullivan sets out the various authorities for use as a dwelling house. And in particular, if I take you to paragraph 15.
Well, 27 is interesting. So starting from first principles, whether the use of a dwelling house for commercial letting as holiday accommodation amounts to a material use will be a question of fact and degree. So A, it's capable in law of being a different thing, and then B, it's a question of whether or not it is on the ground.
Yeah. My Lord, I was going to come back to that.
Oh, okay.
Only because it then goes on to talk about the Blackpool case in paragraph 28.
Right.
So I was just going to go back to what,
Okay.
if that's okay, but that's basically my point, what's said at paragraph 27.
Right, so I'm just reading it just a bit. So where did you want us to go?
So it's paragraph 15 on page 290.
Oh.
Incidentally, perhaps we ought to note that Mr. Lewis in this case was Mr. Gwayan Lewis.
Sure. No relation. There's only 5 surnames in Wales. You get them by rotation. Yeah.
Yeah, so paragraph 15. And could I just ask you to read paragraph 15 and then paragraph 16, the first indent from what was said in the judgment?
No.
And then that's then picked up at paragraphs 27, 28, as Lord Lewis points out, which are highly relevant. Starting from first principles, without the assistance of any authority, whether the use of a dwelling house for commercial letting as holiday accommodation amounts to material change of use will be a question of facts and degree in each case. The house will depend on particular circumstances. Neither of the two extreme propositions, using a dwelling house for commercial holiday lettings would always amount to material change of use, or, and this is the key bit, the use of a dwelling house for commercial holiday lettings can never amount to a change of use is correct. The Divisional Court's decision of Blackpool supports this approach. The inspector would have erred if he'd approached the matter on the basis that there could be no material change of use if the house was in some form of residential use. Not every use is necessary use of a private dwelling house that was entitled to include the character had not materially changed by the particular patterns of holiday lettings in that case. So you can have two uses of dwelling house, use for holiday lettings, that fall within the generic description of residential use. That's a familiar concept in planning law. Whether there is a material change when you go from one to the other, dwelling house to holiday letting, will be a question of fact and degree. So, and I'm now probably straying into the second question on whether the inspector was entitled to reach a judgment that there had been a material change here. Of course she was. Because there's no... The fact that generically the site is a caravan site, both before and after, doesn't mean that the character of that caravan site changes. In the same way in which, generically, you can have a residential use both before and after, but have a materially different character from its use as a dwelling house to its use as holiday lettings. And I'm not going to go through all of the passages in that last section of the report of the decision letter. My lords, I know you've already read it and will reread it. But when you do read it, you will know it is full of planning judgments. It's fully focused on the character of the use, and the inspector is very clear about why permanent residential occupation of all of the caravans is materially different from a mixed use. And the key bit is paragraph 59, I would submit. On page 228. It ties into my Lord Lewis's point about comings and goings, where she says the character of the use of this central area, and that's where the touring units are, would undergo considerable and significant change if up to 80 caravans were to be stationed on the planning unit for unrestricted occupation. The seasonal pattern of occupation with peaks in the summer months and troughs in the winter would be replaced by unrestricted residential occupation that would generate a steady level of activity throughout the year. Areas of the site which are currently devoid of light and other human activity during the winter months would acquire a year-round domestic presence. Now that is the change in character that is brought about by the use, and it's a matter of judgment whether that's material or not. She reaches the overall conclusion at paragraph 65, that's a substantial and fundamental change in the character of the appeal site's use. suppose the benchmark question is, could that be described in an enforcement notice? If it could, then that's a breach of planning control that's capable of being enforced. And it can be. One would almost use the language of paragraph 47. It's a change of use in a caravan site, which caravans provide both permanent residential accommodation and holiday accommodation, to a caravan site which provides permanent residential accommodation. That is material change of use. It's open to the effect to define as material change of use. I mean, Lord, I think the final point I would make is the wider implications of what is being said if the appellant's argument here is accepted. Because obviously, it would have implications not just for caravan permissions, but any planning permission. And the very typical permission, you would have planning permissions being granted for 100 dwellings. Obviously, normally other stuff as well, but planning permission has been granted for 100 dwellings. And sometimes they have a condition on saying you cannot build more than 100, sometimes they don't. If the appellant arguments are accepted, the developer could build 200 dwellings on the site and say it's not a breach of condition, which is not, but it's not a material change of use either, because generically this is a residential site before and after. So that change would not be caught by the planning regime. Whereas applying the inspector's approach, and we would say the approach taken by the case law, if you didn't have a condition, you would ask yourself, does this permission for 100 dwellings permit 200 dwellings? Answer, no. Then you would ask yourself, is the change to 200 dwellings a material change? And you would look at all of the consequences. In some cases you would say it is, in some cases you would say it wouldn't. It probably depends on all sorts of things. So for example, if 105 buildings were built, that might not be material. And that's all fact and degree for the decision maker. But if the appellant's right, it's something that's just not caught by the planning regime, because generically, before and after, it's a residential use. And that, I would say, cannot be how the planning system operates. And it's not what the case law says. So my Lord, those were my submissions, unless there's anything else that I can assist with.
No, thank you very much. Thank you, Mr. Parkinson. Yes, Mr. Leader.
Well, my lords will have noted the overlap between what I have to say and what my learned friend Mr. Parkinson has said so well. So, my lord, what I do not want to do is simply duplicate my learned friend's submissions. It appears to me that the point I have...
Do you formally adopt his submissions?
I
or
do,
not?
my lord.
You do.
Without reservation. And having done so, my lord, it appears to me that the point I have, this is a discrete point, querying the extent to which it advances matters in the light of what the learned friend has said, is the Whipperman point. But the Whipperman point is simply perhaps an alternative way of looking at matters that get the inspector across the line in finding that there was material change of use. So, my lord, I will promise to be brief, and to the extent my lords find that what I have to say is unhelpful, you will doubtless stop me in my tracks and pursue others with any further questions that my lords may have to heard their submissions. So, my lord, shall I proceed with Whipham and see how far we get?
Yes, yes. But there really is, I mean, you've adopted Mr. Parkinson's submissions. There really is no need to repeat any of them.
No.
And those for whom you appear can take note of that. You've adopted those submissions, they become your argument to that degree.
Indeed, my lord. And what I've sought to do while my learned friend has been talking is strike through those areas of overlap that will simply absorb time. Right, enough, I'll get on with it, my lord. I suppose what Whipperman perhaps helps us understand as I develop the points is that a caravan site is not always a caravan site, actually. Caravan sites can just be caravan sites, but it's a case of the circumstances surrounding any particular grant that would make them so. And that first point, my lord, is well illustrated by the Breckland case, because without wanting to drag my lords through that case in detail, if I could take my lords to page 144 of the authorities bundle, let's start there. Because in Breckland, the caravan site was indeed just a caravan site, but it was so for a particular reason. And my lords have seen this decision, Mrs. Justice Lang, my lords have had this case introduced to them earlier. And at paragraph 6, we can see that back in 2006, the Local Planning Authority had been asked to grant a CLUD under section 191 of the Act, and they granted a CLUD in certain terms, and those certain terms did not in any sense seek to circumscribe the use of the land certified as a caravan as well as a camping site. Now that had certain unfortunate consequences as far as the planning site is concerned, because if one goes to paragraph 13 on page 146, we can see that the site came to be owned by somebody else who made an application for certificate under section 192 of the Act, which sought a more particular type of caravan use than that which had been described in the CLUD. And if we then go to paragraph 41, that point is made. The term caravan was not qualified in any way in the 2006 CLUD, even though the claimant, the council, must have been aware of its wide statutory meaning. Oh dear, in a sense, because one then goes to paragraph 50 and 51, and one sees reference to the Broxbourne case. I don't think I need to take my lords there. That 51, we see that the difficulty for the council in this case was having defined the caravan use quite broadly. They weren't later able to say, well, we only meant to say a certain kind of caravan site, which was a touring caravan site, as it turned out, but they didn't succeed because they hadn't ruled out the residential use. So, my lord, a caravan site will just be a caravan site if a local planning authority or local planning authority fails to, in some respect, circumscribe the particular character of that site. Now, as we have heard this afternoon and this morning, one can circumscribe a particular use in a couple of ways. One can do so by characterising a grant in a certain way, or one can do so by conditional, kind of a mixture of both. And, my lord, turning now to my Whipperman point, if I could, having made that general introduction, take my lords to the authority, and I'll try and get on with this. My lord, the case begins within the authorities bundle. On
page
360. And my lord has a version that is set out in the law reports. I suspect my lords have read the head note. We see this is one of the Queen's Bench Division reports from 1965, beginning at page 225. Have my lords had the opportunity to read the head note?
Yes.
Thank you, my lord. Well, then I can move directly to the relevant principle as it's set out in the judgment of Mr. Justice Widger as he was, and my lord probably needs to read the bottom of page 363, the final paragraph, and then turning over the part of the judgment that's set out in the 10 lines. I'm so sorry, yes. if you have,
Well, it's the passage on, if we take the page numbering in the report, in the property and compensation reports, page 280, first full paragraph, in my judgment as a matter of law. That's the passage you want, I think.
it is indeed, my lord.
Yep.
So, my lords, having seen that, the Whipperman principle is really quite straightforward. First of all, one must be dealing with a composite use. I'm going to have to give that a little bit of attention. Secondly, one use must be absorbed by another use, rather than that other use simply being abstained from. And thirdly, the consequence of that absorption must be to cause, as a matter of fact and degree, a change of use of the land. Now, are we dealing here with a composite use? Well, if a caravan site is just a caravan site, I suppose the answer would be no. But my submission is a caravan site is not just a caravan site if it is in some way circumscribed with the terms of the grant or a condition of both. And in this particular case, what did the inspector find? Well, we know, and I'm not going to drag my laws there because we've looked at paragraph 47 of the inspector's decision on page 266 many times, that what the inspector found was permitted was a residential and holiday site. I'm going to characterise it in that way. My laws have got the exact words several times. Was she entitled to conclude thus? Well, she was, because we have looked at the plain English description of the planning permission on page 3 of the supplementary bundle, and it's there to be read and absorbed, and it is quite clear what was granted. Further, that clear description was effectuated by conditions E and F of that permission, which has had the effect, in the way my learned friend has described at length, of causing the holiday use to be a real distinctively different use from that of the residential use. And thirdly, and in any event, that the effect of those conditions is then evidenced by the second condition attached to the 2013 planning permission that my lords have seen at page 5 of the supplementary bundle. So you have the plain English, you have the operation of the conditions, and then you have the evidence of the 2013 planning permission and the condition attached to it, condition 2. So I say that the inspector was entitled, as a matter of fact, to conclude the uses were different, and in fact say mixed use. And if one asks, as a matter of law, was she entitled to do so? Short answer, yes. One can argue by analogy with the case of Moore that the learned friend has taken you to, but in fact the authorities do provide a little more assistance than that, because if one takes as an example the Winchester case that my lords looked at a little earlier today, I don't think I need to take my lords to the case that they will see. One recalls there that the court was dealing with a site for travelling show people. Yes, that is a caravan site, but as the court found, not a caravan site that can be used by all and sundry, because what is permitted is distinctively different from, for example, a residential caravan site for people who are not travelling showmen. And within Winchester, there was reference to another case. Flick back to recall which one it was. Yes, it was Williamson and Stevens. My lord will see that referred to at page 203 of the authorities bundle. Now, Williamson and Stevens was a gypsy caravan site case determined by the Lands Tribunal, again found to be outside of the general category of, if it exists, caravan sites viewed in the abstract. And of course, my lord, it being clear from those two examples that a caravan site is not just a caravan site, it is a genus which has within it several distinct species, one can then see that by dint of a careful description, which we have in this case, of the particular use permitted, and by the application of conditions operating, if you like, indirectly rather than through very direct language, one has carved out in this particular case a mixed use of a residential site and a holiday caravan site that is, in the Whipperman context, a composite or mixed use. And so, my Lord, moving quickly to a conclusion, we know from paragraph 47 of the inspector's decision that what she saw, the appellant wanted to achieve, was the complete absorption of all caravans on the site, whatever their use, by residential use. That is exactly the kind of pattern of change that is contemplated in Whipperman. And then, of course, we have, between paragraphs 53 and 65 of the inspector's decision, as my learned friend took the court to, a very detailed exposition of why it is the substitution of a residential use in place of a holiday use would produce a distinctive change of character and therefore a material change of use. So, my Lord, the Whipperman approach, I can call it that, or the Whipperman analysis, provides my Lords with a way of agreeing with the inspector's legal conclusions, but it's not a necessary approach for the court to follow, because one could follow the more direct approach and learn from Mr. Parkinson and get to exactly the same answer. And my Lords, I think anything else I say would be to simply repeat what my learned friend said, and I won't assist the court in that way, so unless I can assist further, I'll sit down.
Thank you very much, Mr. Lee. Thank you. Yes, just let's clear the deck slightly, Mr. Fraser-Eckert, before you begin your reply.
Yes.
Right, yes, thank you.
Lord, I'm obliged. I said I was likely to be brief, and I will hold to that promise. I've got one or two brief preliminary matters to deal with, and then I'm going to deal reasonably shortly with the way in which Millen and Friends submissions have dealt with the I'm your man and use principle, and then I'm going to comment on Whipham in that context briefly again, and then deal with more. I'll keep my Lord Justice Lewis in suspense until the very end. My Lords, first of all, with respect to Lambeth,
Yes.
the paragraph reference to I'm your man in Lambeth is at paragraph 26, and it's clear there that Lambeth is I'm your man is regarded in that context as being well settled law, and law that's not purported to be disturbed by Lambeth. I don't think beyond giving that reference, your Lordships can see how it's put. I don't need to dwell on that. Secondly, the matter of limitation.
Oh, yes.
Use of the word limitation came up, and there are 2 points to make with respect to that. The first is that there is no definition of limitation in section 336 of the Town and Country Planning Act. Obviously, I've not trawled the Act, but normally one finds the definitions there. Yeah. Secondly, as I'm sure your Lordships will appreciate, that the very language of the General Permitted Development Order, and clearly the term limitation comes up in the context of development orders. But the very framework of that order is to give deemed planning permission for certain specified classes of development, subject in each case to what are called firstly conditions, and then there's usually a separate section of limitations. So the language is certainly emergent from the principal development order with which one wrestles. Secondly,
are the limitations similar to a qualification or description of the thing for which planning permission has been granted?
they tend to be either a mix of dimensions-based constraints, or they impose particular limitations with relationships to distances from roads or the way in which a piece of permitted development might address a
Do they
highway.
have limitations like dwelling house or holiday? What I'm thinking about is this. If the limitation is seen in that context as part of what's allowed, then maybe we...
No, the way the order works is there is a description of what permission is granted for, and then that is subject to a list of conditions,
Right.
and then a list of limitations.
Okay, so I don't really...
So it's not the same interaction of.
No, it's more mechanical, but it sounds...
It's very much it's very much a tick box exercise.
I think I'm right in saying usually it's set out as description of development, limitations, then conditions.
I'm sure your lordship's
That
right.
I think is the structure.
I'm sure your lordship's right. I haven't looked at a case dealing with that for a little while.
Yeah.
But perhaps more...
but for what it's worth, I think your description is, if I may say so, I think your description is correct as to the nature of the limitations in the permitted development order.
Yes.
I think that is right.
But in a sense, that's almost by way of introduction to the main point on this, which is that the issue of limitations, the word limitation was considered in the logic of I'm your man. It's probably worth just digging that out.
Do you want to go to I'm your man? Yes.
Yes, if your lordship.
Well, we can go to that now in the law report.
Yes, if we can take it, that has the advantage of at least internal pagination, and I can take your lordships to the section. It's on page 8 of 12.
Yeah.
And your lordship sees the judge ask himself the question, implied power, question mark. And then there's a discussion about 10 lines down, in my judgment, the references and the enforcement related provisions to breach of limitation as well as conditions equally consistent with the reference to limitations expressly authorised as part of the power to grant permission to buy a development order, but that does not imply a statutory power to impose limitations on permissions. And this is all within the context of earlier acts. And then, considering the next series of acts from the 1962 Act, about 2/3 of the way down the page, your lordships will see the 1962 Act is described as a consolidating act. The omission of section 38 does not provide ground for inferring that the definition of breach of planning and control, which was introduced by the 1950 Act by way of amendment to the 47 Act to include limitations on permission granted by a development order, so that's included, should be construed as conferring a more general power to impose limitation on planning permission granted pursuant to applications under the Act. The framework of what is now the 1990 Act, including the provisions which I've said about above, strongly indicates to the contrary. So it was a finding that you couldn't impose limitations through the 1990 Act, effectively other than by a development order, is I think made out in that case.
Yes.
So, and my lord, the last of my sort of little introductory points springs out of my learned friend Mr. Parkinson's submissions that this was an attempt to sort of overcomplicate or overly legalise this situation, and I was struck by things I read in judgments that my Lord Justice Lindblom has given previously, cautioning against the excessive legality in matters of planning law. But what I do say is that that's absolutely right, of course, but that this is a matter of looking at a particular planning permission in the context of a particular framework of established law. And I make no apology for relying upon that established law as the way of properly interpreting this planning permission. And that really leads on.
You're entitled to say, as a matter of principle, of course, that the task of construing a planning permission is ultimately a matter for the court.
It is a matter for the court.
So to that degree, you use the word legality. But if you want to use that word, the legality of that exercise is inherent in the task at hand.
Yes, it's kind of what a court's meant to do.
It's what courts do.
Yes, I would make that submission. My ears perked up when I heard that submission, and I've been very conscious of that particular facet of your lordship's judgments in the past.
I think we all understand that role of the court.
Yes. And then that really moves on to my two sort of substantive points, because the point that I would just draw out is that all of the analyses that both my learned friends gave all effectively began from the proposition that the inspector was right in her construction or the way she approached the planning permission as dealing with and granting effective permission for, or an effectively limited permission for, the types of particular types of caravans which are listed in the description of the development, the static vans, the touring unit, the residential vans. And I'm not going to repeat all my submissions, obviously, but I just simply draw out that when you analyse those submissions, they do all rely effectively on assuming that they're right all along. And it is, in my submission, again, of fundamental importance to note that, yes, the exercise of construing a planning permission is based on looking at the permission as a whole and looking at it as an ordinary reader might look at it. But it cannot be overlooked when doing that the very nature of the I'm your man principle does mean that certain words which are clearly in the permission are not given effect. I've already submitted on a number of occasions about the time limit in I'm your man itself, but I think it might just be worth, in this context, turning up Alton Kayak again, and that's, my lord, at page 177 of the authority bundles. And my lord, see at paragraph 5 on the paragraph 5 of the judgment, the description of development for which permission was given. Conversion of shop to restaurant, kitchen and hot food takeaway as an extension to the present premises at number 15. And then one sees what was said to be permitted by that permission because of the absence of conditions to impose the limitation. Paragraph 24, my lords, page 182. And it's the bottom of paragraph 24. Mr. Kimlin submits that they were not effective in law to impose a limitation that number 15b could be used for the permitted purpose only as an extension of number 15 and not on a standalone basis. And again, I repeat the submission. If the ordinary reader reads that description of development, it says as an extension to the present premises. If one is simply drawn to a type of interpretation that says, well, it's there in the description of development, therefore it must be good, it must be effective because we're construing the permission as a whole, as an ordinary reader would, the I'm your man principle would fall away. And therefore, in my submission, the construction of this planning permission has to be done on the basis of an understanding and application of the existing law established in the I'm your man line of authorities. And again, the point comes through, again, even more starkly, if I can just again take your lordships briefly to this authority, the Cotswold Grange case, page 188 of the authorities bundle. And this was a case which is, as it were, right in this field. It's a caravan case. And the commission one picks up from paragraph 25 of the authority, page 194. And this is a situation where this was the case where there was an unambiguous limit of 54, or a mention of a limit of 54 caravans in the description of development. But then, as the court considers in the paragraphs below, 27 and following, 28, whether it's there in the form of a condition, and it was concluded that there wasn't an effective limit, or wasn't a condition limiting the numbers, and therefore that limitation that purported to be imposed by the description of development couldn't stand, couldn't be legally effective. And again, it goes back to the same point. The description of the development was clear. An ordinary reader would have said, well, it's a site for 54 caravans. But that wasn't enough in operation of law. That was not enough. And so therefore, what I do say is that when one looks at the construction of this planning permission, you go back to the submission, I won't repeat them all, you go back to the submission that it's the essential land use as caravan site which is being permitted here. And all of these restrictions, no matter how clearly expressed they are, no matter what, frankly, the ordinary reader might make of them, in operation of law they are ineffective because they're not backed up by condition. And therefore, because of that, the inspector has, yes, she's considered the I'm your man principles, and okay, but she's misapplied them. She's got that wrong, and the judge also got it wrong in the way he supported that. And again, I'll just comment, if I may, on the condition. And in a sense, one has the cart driving the horse in this case, because the way the analysis has been put is that one looks first of all at the reason for condition E and F, which is to maintain the appearance of the site in winter, and that drives the interpretation of the condition, and that drives the interpretation of the permission. In my submission, that's completely the wrong way around. You look at the description of the development, and then you see if there's any ambiguity or there's any inability to see what the essential land use permitted is from that way.
But it's ultimately a holistic exercise, isn't it?
It is a holistic exercise, but even a holistic exercise in my submission has to start from the right starting point,
yes,
and not be backwards of face.
It has to start from the right starting point, but finish by being holistic.
Yes.
So you wouldn't resist the contention, which I think was advanced on the other side, and I don't think is controversial, that in construing a particular planning permission, one can gain a deeper or more accurate understanding of the grant itself by seeing what limitations by way of condition, restrictions by way of condition were imposed upon it.
Well, you can, and in a sense, that works both ways.
Of course.
Because if it's thought necessary in the I'm your man world to impose a condition, that suggests that that's what the thing was permitting.
Yeah.
And that there was a need to limit, because there's a condition limiting a certain part of the permission, it's because the description of development was wider. If the description of development could properly be construed narrowly on the terms used, you wouldn't need a condition to do it.
All right.
That's how I would put it.
Yes, I understand.
And I do just draw a distinction here, or a contrast as to the way that you're being asked to construe this planning permission, as it were, from the backwards to the front rather than the other way round. By contrast to the Winchester description, where the description of development was for a travelling show person site, wasn't even for a caravan site for travelling show people. It was just expressed as a travelling show person site. And there, the act of construction starts very naturally from the description of development, and everything else follows on. And there isn't really a great need, to look at it in this back to front way, which I submit as being urged on the court in this case.
Why did that permission not need to be restricted by a condition saying for travelling show persons only?
Because the court concluded that the particular nature of occupation of caravans by travelling show people was functionally different from other forms of caravan occupation. In the same way that travelling show people enjoy a particular status in planning policy and the like.
Functional difference. Yeah, well, you developed that point earlier.
Yes, and I say there's no such functional difference between different types of accommodation, of occupation of caravans. And then I think finally, I'll come to, in that context, the Whipperman case, again, trying to suggest that there's a composite use, as in a composite of two caravan uses. That would be the only way in which the Whipperman principle could apply if there were two caravan uses. Here, of course, in my submission, there's a mixed chalet and caravan use, and that's not disturbed by, or wouldn't be disturbed by the grant of the certificate. And then finally, my lords, I think on Moore, and obviously I fully accept what Moore says about dwelling houses. The point is in my submission that there is a ready distinction that can be made between the way in which dwelling houses are treated in this context and which caravans should be treated.
Why?
Forgive me, my lord?
Why?
Well, that's what I'm coming to.
Oh, sorry.
No, I wouldn't expect in this company just to be able to make that submission and run away. I would expect
finished.
My lords, I'm just pausing to draw out the references. Page 286 of the authorities bundle, the first page of the judgment in Moore. And it's important to note the context in which this matter arises, which is an enforcement notice, paragraph 3. Breach of planning control alleged to be from a C3 dwelling to use as a commercial leisure accommodation. And this is where my contrast comes from, because Parliament has decided to define a particular class of use of a dwelling house and give it its own status as a use class, the C3 use class, which is then set out. And the contrast, I say, is that whereas there are by statute different classes of use of dwelling houses, in statute law, in caravans, the definition is a single use. And that, in my submission, is the essential difference and why one can't rely on the logic of a dwelling houses case in a case where the change of use was moving beyond the class 3 class that Parliament has established into a separate category described as commercial leisure accommodation. Whereas in caravans, we're talking, to go back to my Lord's characterisation of caravans, caravan is a caravan.
And why is a caravan only a caravan? What is the legal reason, or what is the thing that says a caravan can only ever be a caravan, and it doesn't matter what you do in it, or who you do it with, or how long you do it there for, or whether you take it on and take it off.
Because
it's
that's
still
what,
a caravan.
That's what Parliament has said in the way it's defined caravan.
So it tells on section 29 of the relevant statute.
Yes. We did find it. Where did we find it?
It's in Lang J's
The Breckland.
judgment in Breckland,
yeah.
yes. And I think it's defined as a mobile thing, not as a static thing.
It's page 153, my lord, sets out the definition.
Does it include things that are not mobile, things that can't be taken off and brought back on?
No, the caravan has to be something structurally designed or adapted for human habitation, which is capable of being moved from one place to another, whether by being towed or by being transported on a motor vehicle or trailer, or any motor vehicle so designed or adapted, but doesn't include rolling stock, railway rolling stock or tents. So, as I say, the statutory definition of caravan does not include any distinction between static caravans, mobile homes effectively, which require a considerable operation to move them, or a touring caravan which you just hitch up to the back of your car.
So is a static caravan within this definition then?
Yes.
Because it's designed or adapted for human habitation, which is capable of being moved from one place to another.
Yeah. Or by on the
Or
basis
by
of being
being
transported.
So one of the
On a
larger caravans that one sees on these sites.
There are
Could
size
not- could not-
limitations.
Yeah,
or size
subject to size limitations.
Subject to size. But in
But they
theory,
can be
yes.
put on a heavy duty trailer, and
The things you see tootling up and down the motorway with
yes,
extra wide load
wide
vehicles,
loads,
they're caravans, subject to size limitations,
Yes.
they're caravans
Yeah.
within this definition, Lords, yes. So, Lords, that's why I say there's a distinction to be drawn with more. Because Parliament has decreed it, effectively. So, my Lords, unless I can assist further, those are the points I had by way of reply.
thank you very much. Yep. Thank you very much, Mr. Fraser. Thank you. Well, we're very grateful to all of you for your very clear and concisely presented submissions. And in saying that, of course, we heed also the care that was taken in the preparation of skeleton arguments by all of you. We are grateful. We're going to reserve our judgments. They will be handed down in due course. The procedure will be the normal one. A draft of the judgment or judgments will be sent to the parties in advance of the hand down for the purposes of typographical and minor factual corrections. A draft order is to be agreed by the parties if at all possible. Any consequential submissions should accompany the draft order. Thank you all very much.
Bye.